Hello, everyone. I think we have a couple people filtering in, but I think we're going to get started. Welcome, everyone, to the 13th Annual Justice John Paul Stevens Lecture at the University of Colorado Law School. In addition to our students, faculty, alumni, community members, and those joining us online on the live stream, I also want to recognize the presence of other special guests and distinguished members of the Colorado legal and jurist community. We're joined today by Justices William Hood, Brian Boatwright, and Maria Birkenkotter from the Colorado Supreme Court, who are also with us this morning to hear cases. Judge Timothy Timkovich from the United States Court of Appeals from the 10th Circuit, and some members of the Colorado Attorney General's Office, Natalie Hanlon-Lay and Tanya Wheeler. We're grateful for all your engagement. Before proceeding, I also want to recognize the law event staff, Lindley Bell and Yesenia Delgado, without whom we could not have been able to organize this event, as well as the Byron White Center student fellows who have been instrumental in helping plan. Finally, for the attorneys in the room, there is CLE credit available for this event. There's a notice outside on the registration table with instructions about how to do that. My name is Deep Kulasekaram. I'm Provost Professor of Law here. I teach constitutional law and immigration law. I'm here today, though, because I have the privilege of directing the Byron R. White Center for the study of American constitutional law. The namesake of the center was All-American halfback and Heisman runner-up for the University of Colorado football team, Sco Buffs. But that's not why the center is named for him. Byron White also served as the Associate Justice of the United States Supreme Court from 1962 to 1993 and was the first such justice from Colorado. In fact, in a happy coincidence, our speaker today, clerk for Justice White, and is the first former clerk to Justice White to deliver the Stevens Lecture. The Byron White Center was created in 1990 as part of a generous bequest of Colorado law alum Ira C. Rothgerber. The center's mission is to advance excellence in constitutional legal scholarship, provide opportunities for Colorado law students to promote justice, and to expand public knowledge and informed discussion of our Constitution. The center does this by organizing several events in the fall and spring to advance this mission, including hosting the Colorado Supreme Court in the 10th Circuit, Constitution Day, going out into the field to teach about the Constitution in area schools, mentoring high school students through the Marshall Brennan Constitutional Literacy Project, hosting the Rothgerber Conference in the spring, and our signature fall event, the Justice John Paul Stevens Lecture. The Stevens Lecture was inaugurated 13 years ago by the namesake of the lecture series, Associate Justice, U.S. Supreme Court Justice John Paul Stevens. Since then, we've been graced with the wisdom of Supreme Court Justices Ruth Bader Ginsburg, Sandra Day O'Connor, Antonin Scalia, Sonia Sotomayor, and Elena Kagan. We've also heard from circuit court judges from the 10th and 6th Circuits, state Supreme Court justices from New York and Hawaii, justices of the Potawatomi Nation Supreme Court, and the South African Supreme Court. Today, we add another prestigious name to that list with the presence of the Honorable Stephen A. Higginson from the United States Court of Appeals for the 5th Circuit and presiding judge of the United States Foreign Intelligence Surveillance Court of Review. Judge Higginson is a scholar, legal thinker, and jurist with few equals. His CV is filled with every single gold star imaginable in the field of law. For space limitations, we could only include a select highlights in the bio that you have in the program. So I'm going to take a moment now to introduce him more fully. He was born and raised in Boston, and he graduated with a degree in English literature from a little-known local hometown college, Harvard University. He then went on to study at Cambridge University, where he earned his Master's of Philosophy, then to Yale Law School for his law degree, where he served as editor-in-chief of the Yale Law Journal. Following law school, he clerked for Judge Patricia Wald of the D.C. Circuit before his time with Justice Byron White. Judge Higginson then began his long career as a government lawyer and public servant, serving as an assistant U.S. attorney in Massachusetts before moving to the U.S. Attorney's Office in New Orleans, where he became chief of appeals in 1995, working both as a federal prosecutor and supervising the appellate litigation of that office, much of it in front of the 5th Circuit Court of Appeals, the court on which he now sits. His career as a government lawyer was highly distinguished, including being recognized for special achievement by U.S. Attorney General Janet Reno in 1993, and receiving the Justice John Marshall Award for Outstanding Legal Achievement in 2003. And these are but two of the many accolades in his time with the DOJ. In May 2011, in one of President Barack Obama's most notable decisions, he nominated Judge Higginson to the Fifth Circuit. He was confirmed to that seat by a Senate vote of 88-0 and has since served 13 years on the federal bench. In addition to his service on the Fifth Circuit, Chief Justice John Roberts appointed Judge Higginson to serve on the United States Foreign Intelligence Service Court of Review, and in August 2023, he was appointed presiding judge of that same court. Now, I left two final things out of my introduction of Judge Higginson, both of which speak to my personal connection with him. The first is that from 2004 to 2011, while still a Department of Justice lawyer, he was full-time faculty at Loyola New Orleans School of Law, teaching criminal law, constitutional law, and evidence. I mention this because this is where I first met then Professor Higginson, as we were both in our first years of full-time law teaching. I was struggling and muddling through one class of constitutional law, which was not only my full-time job, but my only job. Meanwhile, Steve was earning rave reviews for having taught the best evidence class ever taught at Loyola Law, in between maintaining his position with the U.S. Attorney's Office in New Orleans. Now, I'm not just saying he was an amazing professor to be nice. He won the Law School Professor of the Year Award in 2006, 2007, and 2009. And lest you're wondering why he didn't win the award in 2008, that's because that year he was named the university-wide outstanding teacher. I do have to note, though, that I left New Orleans in 2005, which could just be coincidence, but I like to think it's because I relieved students of the burden of choosing between me and Steve. Even though it was only 1 year together, what I mostly recall is Steve's warmth and kindness, his deep curiosity about the law and legal problems, and the sharpness and detail of his legal thinking. Right after law school, right after I left, we struck up a friendship that would continue well after I left New Orleans, which brings me to the second connection that we have. I clerked on the Fifth Circuit in New Orleans for Judge Jack Weiner. Judge Weiner and I speak regularly, and in 2010, he told me he was taking senior status. In 2011, in one of our conversations, after he made that decision, I asked if he knew who would be taking his seat. He said, "It sounds like it's going to be Steve Higginson, and I don't think they could have made a better choice." Now, that quote and that story may sound apocryphal, but I can tell you with certainty that it is true because Judge Weiner repeated that same statement to me 2 weeks ago. I called him on the occasion of his 90th birthday to wish him. In the course of our conversation, I told him that I invited Judge Higginson to deliver today's Stevens lecture, and he said to me, "I don't think you could have made a better choice." So as you can see, it is both my professional and personal delight to present our Stevens lecturer, Judge Stephen A. Higginson, who's going to be speaking about the Nuremberg trials. After which, I'm going to have a conversation in our fireless fireside chat format to discuss his remarks. And if you guys are lucky, I will leave you guys time for Q&A as well. But if we don't have time, we all have a reception in Betcher Hall next door where you can also meet Judge Higginson. Please join me in welcoming Judge Higginson.
I wish Justice White were here, because if he heard that I had a lot of gold stars, I could hear his gruff laughter at that thought. One thing you learn clerking for Justice White was humility. During my year with him, one afternoon, I left a little before 5. I was working on the top floor of the Supreme Court. Didn't think I'd run into him. I was invited to an event that I went to. When I got there, the hostess welcomed me and said, "Come on in, but I want you to meet somebody." We turned the corner, and she said, "Justice White, this is a future lawyer." I was clerking for Justice White, and I had left the court early to go to this event. And he grabbed my hand and said, "Oh, I know the great Steve Areno," which was his nickname whenever he wanted to reduce your hubris. This is a wonderful invitation. It's a great honor to give the Stevens lecture. The opportunity is also special because of my friendship with whom I know as deep, the director of the Byron White Center. We did start teaching in quirky New Orleans together about 20 years ago. I do read his scholarship. He writes especially in immigration law, which my court sees a terrific amount. And when I read what scholars write, it deepens my apprehension that judges decide cases so pressed by the volume and the urgency of our docket that we're very rarely connected to the layers of insight that scholars have given us that in their fields of study. To the law students here, you should be very excited to enter the profession. I love being a lawyer, first in New England and then by serendipity in New Orleans. Here's a promise, and it's a comment about the weighty responsibility that you're going to soon inherit. We judges are very dependent on you. Lawyers present and they illuminate cases. You're in control. It's rarely the judge who deserves credit when an opinion is written. It's the good lawyers who wrote them. And I think about that when I think about lawyer Thurgood Marshall, who wrote Brown v. Board of Education, when he expounded on the word equal to overturn Plessy, telling the Supreme Court that we've grown up and then desegregating America. I think about that as to lawyer Ruth Bader Ginsburg, who as director of the ACLU Women's Rights Project, took our Constitution's promise of equality also to get women on juries and to get women into occupations like law enforcement, dismantling paternalistic laws across the country. And recently, a lawyer some of you may not know, Mary Bonato, who expounded on that same one word in the Constitution, convincing first the Massachusetts Supreme Judicial Court and then the United States Supreme Court to protect gay marriage, which allowed me last year to officiate a family wedding. Thanks also to my other colleagues who are here tonight. That's a great honor from the Colorado Supreme Court, and especially my colleague, Judge Timkovich. He is an Article III luminary. He really is someone with gold stars. We sit together on the Foreign Surveillance Court, you heard. And what I'm not going to dwell on relating to him is that the Supreme Court last June, in a case called Garland versus Cargill, taught me that I should think hard before I disagree with a graduate of this law school about how to interpret statutes. Finally, it's a treat to teach here. I mentioned that I clerked for Justice White about 30 years ago. He taught his law clerks many things. Your Attorney General, Dean Emeritus Phil Weiser, is proof of lessons learned successfully. Let me describe one other lesson I learned from failure. When I clerked, Justice White had a 10-day rule, which meant anything you wrote, cert petition, full draft opinion, had to be completed in 10 days. The day after Christmas, he came into my office and he said, "How are you doing?" I thought he was asking about Christmas, so I said Christmas was lovely. It was the one day we had off. The next day, I went into his office to give him a draft of opinion on what I thought was my 10th day, and he just looked up and said, "Oh, Steve Areno." It wasn't great, Steve Areno. "I don't need that anymore." I was a day late. I had counted Christmas as a day. Now, I've never been late on anything since then. If I ended this talk now for the law students here, I would say there is life in the law after mortification. But turning to my topic, and I'm going to try to be provocative because people are polite listening to judges, but if you're coming in this evening to hear me, I might as well be provocative. Justice White was allergic to affiliations, even to his own past when he was known nationally as Whizzer from his football days. I never will forget the memorial service here in Colorado when then Chief Justice Rehnquist perceptively remarked, "There will never be a Byron White School of Jurisprudence." That stuck with me. A compliment that a judge or a justice has no allegiance to a judicial philosophy. There will never be such a thing as a Byron White School of Jurisprudence. Justice White and Justice Stevens both served in the Pacific in World War II. That's true also of Judge Reeves, Judge Wisdom, Judge Tuttle, and Judge Brown, the four judges on my court who were able to see race differently to faithfully apply Brown v. Board of Education. All those men had military service in World War II. It's not a coincidence that having fought and died together, Black and white Americans, they freed themselves of a societal servitude which obscured the judicial duty of so many federal judges across the South, and therefore they were able to follow the Supreme Court's command to let children go to school together. My topic tonight is the peril of affiliation as equal to or greater than the peril of indifference. To explain that, I am going to set my talk into a very tragic moment in our past. But as a positive, it also gives me an opportunity to introduce you to three women from that era who to this day continue to inspire me. One is named Sophie Scholl. She was a student active in the White Rose anti-Nazi resistance group. She was convicted of treason for handing out anti-war leaflets at Munich University. Younger than most of you law students, she was beheaded in February of 1943. Her last words were, "The sun still shines." The second is Judith Sklar. She grew up in the same decade, also in a German-speaking family, but a Jewish one named Nis. Unlike the Scholls, the Nis family fled through Sweden, the Soviet Union, Japan, Canada, eventually getting to Harvard, where I was fortunate to be taught by her. The third is a woman I've added since I first sort of coalesced these thoughts. She, too, is someone everyone should know, but few do. Her name is Frances Oldham Kelsey. I'm guessing almost nobody in this room, maybe a few do. I'll return to her at the end. So, Nuremberg Lessons for Lawyers. When I began to do research, I imagined I was in Widener Library at Harvard. I imagined it was 1962-63 because my great mentor, Judith Sklar, was reading the Nuremberg trial transcripts then. She was a graduate student. She read in the original what I recently read in English, thanks to Harvard Law School's library, which has put the entire Nuremberg trial project online for all of us to read. That's a shout out. Unlike Sklar, I am not a scholar. My talk is my weekend work. It is non-case work. I have done it without law clerks or lawyers, which is when judges can easily step out of our lane. That's not false modesty. It's the acknowledgement that few judges are scholars or historians. And extrajudicial activity and speeches are not our role. Unlike our word in opinions, no obedience is owed to whatever a judge says extrajudicially. With that disclaimer, the students here, who I'm primarily speaking to, imagine you were born at the beginning of last century into a German-speaking family in Europe, like the Nis family or the Scholl family. And imagine that unlike the Nis family, so like the Scholl family, you were unable to escape. That could mean that you ended up as a graduate student in Germany living in an imperiled democracy, but you were unaware of that. The world around you seemed Manichaean, cleaving into a choice between extremes. For obvious reasons, you distrusted the Soviet example. Then you heard of a charismatic strongman who promised to make Germany great again, avenging its loss in World War I. Every defendant at Nuremberg made that choice. Reading their testimony, their choice to affiliate at about your age made clear to me that they didn't make that choice out of ignorance or indifference. They largely made it out of ambition, the consequence of which 2 decades later put them on trial and led many to execution. Allegiance to National Socialism gave the Nuremberg defendants brutal professional advantage, specifically the elimination of competition. Jewish doctors and lawyers were delicensed, giving non-Jews professional advantage, particularly the 2 defendants that I will talk about. One was a doctor who was complicit in human experiments and genocide. The other was a judge who sent over 100 defendants to execution. The first went to trial in what was known as the doctor's trial, the second in the justice trial. My purpose tonight is not to describe the horrors of those trials, but it's to describe how 2 professions, including our own, collapsed in such a short time. And my conclusion is that both professions collapsed because lawyers and doctors and judges chose to affiliate out of ambition. And that choice led to a world war, to the Holocaust, and ultimately to Nuremberg on charges of crimes against humanity. But the 2 defendants that I am going to focus on add a twist. Each was let go. Both affiliated with a group and an ideology that became a servitude that disfigured them with cruelty, sacrificed millions, but both were acquitted by the military tribunal that adjudicated them, despite proven and confessed complicity. So my interest reading the Nuremberg trials was to answer as a judge, why? That's the question that I'll try to answer in this lecture. Defendant Kurt Blom and defendant Herman Kuhorst each took the stand and they testified in their own defenses. As I researched, I wondered primarily, did they say something that possibly could have set them free? In the end, my best answer involves 2 concepts that I think about as a judge, and I hope some of you will value in your careers. The first concept comes from Judith Sklar, my thesis advisor and mentor. She wrote a short essay about human cruelty titled Putting Cruelty First. She tries to answer why cruelty should be what we most try to avoid and what causes it. Her answer is eloquent and more subtle than I will summarize, but essentially she says groupthink does. Group affiliation does. It does because group affiliation excludes non-adherence. ideology and group affiliation, they get their very oxygen from a claim of exceptionality, and therefore by disaffiliating others. By definition, Sklar writes, affiliation to an ideology is incompatible with equality because it is excluding others. To fight that, she has an equality imperative she calls negative egalitarianism. We should always oppose inequality for the negative reason that social distance and perceived superiority are the climate of cruelty. When we don't treat others as equal to ourselves, we mistreat them. The second concept may be one you're more familiar with. It's from Primo Levi, who survived Auschwitz. In his final work, The Drowned and the Saved, he explored a bleak concept that he called the gray zone, where good and evil blur. From his experience, only his experience, he suggests that concentration camp survivors could have survived only if they were, and this is his word, complicit. Now, I won't venture into his exact meaning. He killed himself. The concept is very sensitive, especially if it's applied, as he did, to persecutors, not just victims, implying that persons who inflicted great cruelty could still have humanity, which he called gray. For my purpose, this talk about the lessons from these two Nuremberg acquittals, the first concept, negative egalitarianism, is preventative. It's a caution. Always avoid, always resist political affiliation to any group that denigrates others. The second, my understanding of Levy's gray zone, assumes that you aren't able to stop ideology and cruelty, so some are in and some are out. And in that circumstance, Levy seems to tell us we still must discern degrees of complicity as the Nuremberg tribunals clearly thought they did. So to summarize, to try to make sense of the Nuremberg justice and doctor trials, especially the acquittals, the importance for me of Sklar's and Levy's lessons strike me as explanatory and worth offering to you. The Nuremberg defendants, future doctors and lawyers, at about your age, again, out of ambition, they embraced a mendacious ideology destructive of equality, with a false promise to restore national greatness. German doctors like Blom endorsed the state ideology by practicing eugenics and euthanasia on a genocidal scale. German judges like Kuhorst aborted due process, issued race defilement rulings, and executed enemies of the state in furtherance of the same ideology promising to restore German greatness. That ideology, cruelty towards critics, towards the vulnerable, towards people that are different or marginal, is the ideology Judah Sklar devoted her entire teaching life at Harvard to teach against. And of course, it's the ideology that young Sophie Scholl gave her life up fighting against. The medical trial and Kurt Blom. Robert Jackson, our 82nd Associate Justice of the Supreme Court, took a leave of absence to serve as the United States Chief Counsel for the prosecution of the principal Nazi war criminals. Those proceedings were numerous, but there were also secondary level proceedings, subsequent ones presided over by military tribunals. Those were looking at culpability across professions. And I will start with defendant Kurt Blom, who was in the medical trial. The trial exposed his embrace of National Socialist ideology. The trial detailed grisly proof that the defendants, despite being doctors sworn to adhere to the Hippocratic Oath, discarded the oath by deciding some life was unworthy of life and by carrying out human experiments without consent. As a judge today, when I assess a criminal case verdict for sufficiency of evidence, I look at three moments first in the trial record. I look at the jury instructions for the law. I look at closing arguments to understand the competing narratives. And then if the defendant testified, I look at cross-examination. So I'm going to start with the cross-examination of him to extrapolate a few lessons that I think are consistent with the concepts I've mentioned from Sklar and Levy, negative egalitarianism and the gray zone. So the prosecuting U.S. attorney was named Alexander Hardy, and his cross-examination began with these two questions, which I think show the consequence of political affiliation. His first question was, quote, when your medical education was interrupted by the last war, you resumed your medical studies in 1919. Is that correct? Yes. In the year 1919, what was your political attitude? Second question to Dr. Blom, what was your political attitude? And through life, you all know you will be asked what your political attitude is. The Senate Judiciary Questionnaire that we fill out. I was describing to some students today, one of its questions asks you to list every membership you've had since law school. So affiliations matter. There's something you are accountable for. Choose very carefully. Think about your future self. In the middle of cross-examination, Blum twice answers the prosecutor's question with a question. Now, in my experience as a judge, doing that is very risky. It's more risky even than answering with humor. Humor occasionally can add levity if a lawyer offers it. Once I had a lawyer rise up in front of me. He had the second case of 4 in a day. He had listened to the one before. He stood up and said, "You know, Your Honors, I know the answer to the one you just heard, if you'd like me to do it." That was humorous. It was a moment of levity. We did not ask him to give us the answer. It was funny. But generally, don't joke. And even more emphatically, I would say, don't answer a judge's question with a question of your own, not even to clarify. It's better to say, you know, I may be misunderstanding the question, but, and then give your best answer. But if you do answer a question with a question, be resolute. It's courage you're going to need when you face a judge you fear has prejudged your case. So the problem isn't dullness. It isn't disinterest. It isn't a judge who's lack of prepared. It's more difficult. It's a known hostility to your position. Now, you may hear that hostility in sarcasm as well as in content, so both tone and content. It could come with a barb, a false premise, or a misstatement of fact or law, which you have to correct. It may try to trap you with reference to extrajudicial sources. That's very delicate. The legal arena that the law students here are entering is pretty much a Wild West right now because given the internet, there are sources of authority from diverse areas, which judges sometimes, if you look at judicial opinions, you'll see quite a few citations to the internet. Frequently, the hostile prejudged question is an encumbered one. It's defiant of precedent. It's defiant of party presentation. So that's very hard to prepare for. It's not impossible to prepare for if a judge you sense has an outcome preference. Often it has a root in a group affiliation. That group loyalty can be discoverable. It could be a loyalty to a state, to a prior employer, to some group membership. It could even be a loyalty to a favored, professed judicial philosophy. Judges with judicial servitudes like these, I think, are revealed often in their oral argument questions. It's typically hard for them to ask questions that are difficult to the side that aligns with their affiliation. And to the side that's oppositional, the judge may resort to rhetorical questions, that is, questions that seem indifferent to an answer. So a leading question is one that elicits the intended answer. The rhetorical question, which is the sharpest arrow in the quiver of an encumbered judge, is framed solely for effect. It is a statement intended to make any answer you give superfluous. Now, you have access to oral arguments in a way that prior generations never did, not just at the Supreme Court, but at every circuit level. Take any salient decision, salient and controversial, guns, voting rights, religion, reproduction, read the decision, then go back and listen to the oral argument and grade each of us. Did the inquiring judge ask any hard questions to the parties whose position the judge ultimately upholds? Could the judge even formulate a hard question to the lawyer whose side the judge later vindicates? In other words, I'm asking you to measure us. The transcripts are there, just like the Nuremberg trial transcripts are. Most of our proceedings, conferences, etc., are secret. But more and more with oral argument audios, you can listen to how we converse with counsel. Now, judges who come and prepared to test both sides of a case, they're really testing themselves. Of course they are. They've come in with a viewpoint based on the briefs and based on discussions with their law clerks. But then typically the best judges, the ones I admire most, will ask hardest questions to the side whom they ultimately vindicate. They're trying to be sure they're right. Those are the judges that I respect most and I learn from. So now I've got to get back to Blum in Nuremberg. And the 2 times I tell you he questioned his questioner. First, at page 4679, if any of you are tempted to go into the Harvard Nuremberg trial project, I found this exchange. And I credit Blum here. The prosecutor asked, I note at page 238 of your book, you state that from 1931 on, you marched regularly with the SA. That was a paramilitary group that was dedicated to violent political intimidation. We call it brown shirts, stormtroopers. And he finishes his question with a rhetorical question. You were pretty proud in those days, weren't you? Now, Blom answers, perhaps you want to reply to that question? Aren't you supposed to put a question, if I'm not mistaken? Hardy then says, strike it, doctor. We'll go on to the next. That was well done. That was a witness who said, no, you've got to ask me a question rather than make a political rhetorical statement. He forced the prosecutor to retreat from improper insinuation. The next, however, is an opposite lesson. This time, Hardy's impeachment is jugular, and it's a fair question. It exposes Blom's servitude to the predatory ideology that he had subscribed to and that had advanced his career. Question, what were your ideas along racial lines, doctor? Blom's answer, could I please ask you to ask an individual question into this matter? It might take too long. Well, I'll get to the core quickly, doctor. You were decidedly anti-Semitic, weren't you? Blom, may I ask what you understand anti-Semitic to be? So I can correctly answer the question. Hardy, that you were in favor of any program as instituted against Jews. Trapped, Blom ramblingly admits to ardent anti-Semitism. This sequence of questions and answers reminds me of cases that came up during the civil rights era, when states, even in arguing in front of the Supreme Court, were asked how they could deny that their institutions were segregated. And I remember one in particular where Louisiana was trying to deny that having red and blue bookmobiles for whites and blacks actually wasn't segregated. The Attorney General tried to deny that fact, caught by irrefutable volume record evidence. He then retreated to pretended bewilderment, a little like Blom, asking about what's the meaning of segregation, suggesting that it could mean different things to different parts of the country. So in this second cross-examination moment of Blom, exposing his racial animus and affiliation, to me, the prosecutor proved Sklar's proposition that without negative egalitarianism, we do turn cruel. People who see others as less than themselves end up tolerating and eventually inflicting cruelty on them. But I told you at the beginning, Blom was acquitted. So goodness, how? My best answer reading the trial transcript is that yes, if you commit to an ideology that condemns others, as Sklar warned, that choice will doom you. But still, as Levy tells us, there are degrees of complicity. And let me illustrate the gray zone point with a few other moments from the transcript. Blom had written an autobiography titled The Fighting Physician, published in 1942, which sold 40,000 copies. And if membership and affiliation are as condemning as I tell you they are, this book should have convicted him. In it, seeking to promote himself at the height of National Socialism, he boasts about his anti-Semitism, his commitment to eugenics, his commitment to euthanasia, even to human testing of prisoners to help the war effort. And throughout, he proclaimed staunch support for Hitler. Not surprisingly, the prosecutors made that book their centerpiece. Now, you will learn as you enter the law that confessions, statements of party opponents, are and can be showstoppers. But I predict as lawyers, you'll learn that confessions also contain gray. They contain risk, because after all, it is your opponent's story. A confession will incriminate, but it is that person's story. And Blom didn't deny what he'd written, although he had occasionally tried to excuse it, self-incrimination by virtue of mistranslation, he claimed. But he rarely displayed anger, and he stubbornly asserted context as a counter-narrative. For example, he had to admit that ambition had led him to secure the second highest public health position in the Third Reich, deputy to a man named Leonardo Conti, an incompetent but viciously opportunistic doctor who rose higher with the support of Himmler and Göring, and he became the Reich's health leader, and whose guilt in mass sterilizations and forced euthanasia of mentally ill was so compelling that, like others, he committed suicide rather than face trial. Conti had co-founded the Nazi Physicians League in 1929. Now, I want to stop on that. He created the Nazi Physicians League. Think about that as an affiliation. A parallel medical society networked into the Nazi Party, Can you think of anything more destructive of a profession or a religion than that type of political entanglement and control? Through the Nazi Physicians League, Blom ruthlessly advanced his career by attacking and disaffiliating the Jewish physicians, by pushing paramilitary conspiracies, and above all, by understanding that power was wherever Hitler was. Blom did occupy a more subordinate position than Conti, and that meant he had deniability. Likewise, he wasn't the doctors in the concentration camps actually testing humans. So he had a double layer of deniability. That position itself, I've thought about, is a sort of gray zone. In other words, he didn't originate, as Conti did, some of their policies, nor was he an immediate inflictor. And sure enough, he took every opportunity at trial to highlight where he had resisted Conti. He called a witness, Dr. Cosmel, to corroborate that occasionally he opposed state control of the medical profession. Now, he also professed remorse, unlike many defendants. He tried to excuse his guilt by telling the tribunal that all Germans had been enslaved. Listen to this bizarre final statement he made. Quote, "For years I held a responsible position in a system which I must curse, just as much as curse all those who forced upon the German people such a tyranny of crime and debasement. It was my mistake that I stayed in the post where fate had placed me, and in which I hoped to be able to do good for our people and our profession. It would have often been simpler to give up this post when I realized step by step the depravity of the Third Reich. If I did not do so, but I stayed at my post until the bitter end, I did it because I considered it my duty in the hard times of total war." That's hardly exculpatory, is it? Blom needed something more. I knew from the tribunal's judgment acquitting him, they crucially credited one defense exhibit, a letter he wrote responding to Arthur Greiser. He was the German military governor in occupied Poland, and he too was a violent racist. He expelled and gassed thousands of Jews and Poles. After the war, he was tried and hung by Poland's Supreme National Tribunal. With Himmler's support, Greiser had written to Blom his fear that thousands of Poles had tuberculosis and might infect German soldiers. In response, Blom wrote a letter dated November 18 where he discussed three options. First was Greiser's requested special treatment of all sick Poles. Special treatment meaning extermination, which Himmler had approved. So Greiser and Himmler want to get medical approval to exterminate 40,000 Poles. Second was forced isolation of all sick Poles. And third was migration to a reservation for them. Now, we know from the exchange that Blom considered Greiser's request to treat infected Germans versus specially treat, i.e. exterminate, 35,000, 40,000 ill Poles, versus medically treat less ill Poles, quote, in order to save them for work. Blom wrote brutally, yes, special treatment of infectious Poles would be the simplest solution. But interestingly, he then asked Greiser, quote, to make sure once more that the Fuhrer will really agree to such a solution, writing that he, Blom, saw a distinction between extermination of infected sick people of a subjugated nation and euthanasia. Now, that's still unimaginable as a horrible distinction, but you're beginning, perhaps, to see a little gray in this. Blom then said, well, absolute secrecy would overcome all scruples about the first option. That's totally incriminating. He then adds that he thought secrecy, however, would be impossible. Relatives would someday notice that something was not quite right. Those are his words. News of the program would leak and be taken up by enemy propaganda, which Blom noted had happened with, and I quote, Germany's, quote, euthanasia program. So he put in writing his reference and knowledge of the euthanasia program. But in the end, crucially, he recommends against extermination. He favors the third option, that TB-infected Poles will be forced marched to a reservation. Now, during direct examination, Hardy strongly objects to Blom's insistence that, quote, referring to this letter that he wrote, quote, I am accused of being a murderer for a crime which I did not commit, but which I, in fact, prevented. That was his interpretation of the letter. Hardy was overruled, leaving the prosecutor to try to show that the letter was what he called a masterpiece of murderous intention. The letter is subject to 10 pages of intense cross-examination. You can read and judge for yourself. It's clear to me that Hardy knew the exculpatory power of the letter. Hardy tries to get Blom to acknowledge that he contemplated option one. He said the simple treatment was special extermination, that he knew about the euthanasia program. But in the end, right or wrong, the tribunal accepted the letter for what Blom said it was, opposition to extermination. And here's what they wrote. This is the military tribunal in Nuremberg. It at least raises a reasonable doubt in our minds concerning the matter. Blom knew Hitler and Himmler. He well knew that any objections to special treatment based on moral or humanitarian grounds would make but small impact on the minds of men like those Nazi leaders. He knew, moreover, that before Greiser's proposal for extermination would be abandoned, a plan which appeared to be much better had to be suggested. If viewed from the standpoint of factual and psychological considerations, it cannot be held that the letter was not well worded when considered as an attempt to put an end to the plan originally proposed, to bring a substitution of another plan not so harmful. Whatever may have been its purpose, the record shows that in this particular, the letter did in fact divert Himmler from his original program, and as a result, the extermination plan was abandoned. Just because of time, I'm going to switch to the justice trial. This trial lasted 11 months. It included 100 witnesses. Of 16 defendants, 1 committed suicide. There was 1 mistrial, and 4 were acquitted. The underlying tragedy is the same story of professionals affiliating with violent nationalists out of ambition, leading to servitude, political capture, and disfigurement, this time of lawyers and judges. Very quickly, the legal profession, like the medical one that I just described, collapsed into an instrument of the National Socialist political and ideological purpose. Now, this story also is not just a once-in-time peril to our profession. When I joined my court, I did my best to study its role in the civil rights era, especially the famous James Meredith case and the integration of Old Miss, as well as what's known as the Second Battle of New Orleans, where Judge Skelly Wright desegregated the Orleans Parish schools. I remember being very intrigued by a civil rights report that came out that asked why Judge Wright was so left alone when he was vilified for implementing the unanimous Supreme Court's decision in Brown. Why didn't lawyers sworn to uphold the rule of law support Judge Skelly Wright? This report, that's a retrospective, regretfully notes that lawyers are often inhibited and constrained by their professional circumstance. But it notes that law schools are not. Now, of course, there are students like Sophie Scholl who seem to more easily challenge and defy authority, whether it's out of courage or conscience or wishfulness or just exuberance, even when it's misguided. Recently, I spoke at Yale to disagree with a colleague of mine that federal judges should be out admonishing law students or boycotting law students. My opinion is that our country is strong because of the nuisance value of universities, not in spite of it. But guess which group the Civil Rights Report put most blame on for failing to defend Judge Skelly Wright? It was Tulane's law school faculty. Having once had academic tenure, now having judicial tenure, I think about that. It's likely the law students here have already read the Caroline Product footnote 4 that has given us so much constitutional law that we have today. It was written in 1938. And you know the framers of our Constitution gave us life tenure so we wouldn't have fear or any excuse when a case requires us to protect rights that are imperiled by a political or majority pressure. With academic tenure, law faculty have no excuse to be inhibited either. They have the knowledge and intellect, not to mention the captive audience of future lawyers, to probe, to expose, and especially to criticize judicial opinions and extrajudicial activities that judges take that law professors think are flawed. But back to the history and the Nazi decimation of equal treatment under the law. My focus is not going to be on the glaring due process injustices, either at the front or in German-occupied lands, decrees like the infamous Fog and Night Decree, or later the Terror and Sabotage Decree. My focus is on cruelty inflicted by judges inside Germany. against persons that judges labeled as different or as enemies of the state. The Nazification of German law manifested itself in many ways. Again, I'm not a scholar of this period. I'm just a judge who has read it. Notably, it was harsh summary judgment rulings from what were called people's courts, which had been set up with expedited procedures and rules of evidence with limited or sometimes no right of appeal. And even then, when the people's courts weren't harsh enough, the executive branch had authority to nullify sentences that were seen as too lenient and to execute defendants. In other words, cruel judges could be overruled when they weren't cruel enough. Defendant Hermann Kuhorst sat on the Stuttgart Special Court from 1937 to 44. He was more than cruel. He joined the National Socialist Party in 1930. Before getting on the bench, he worked in the Justice Ministry, revoking licenses of German lawyers. As glaring as the Nazi Physicians League, there was a National Socialist League of Law Guardians. It emerged yet again as a parallel professional society. And it became a Nazi organization with over 100,000 members affiliating with it. I hope you see the parallel. Both professions collapse when parallel societies emerge that are entangled with politics. Like Blom, Kuhorst advanced himself, delicensing Jewish colleagues. In 1937, he was rewarded. He was appointed chairman of the special court. And as I told you, on that court, he sentenced more than 100 people to death. The trial testimony at Nuremberg described him as his bloodlust. He enjoyed signing death warrants. He allegedly said with bravado, quote, "Voila, gentlemen, off to the slaughter." Or, quote, "Well, today we have 3 cases. There must be at least 2 heads." Once again, I wondered, how conceivably an acquittal? This time, but I have less time because I want to save for questions, I'm going to start directly reading the tribunal's judgment of acquittal so we can listen for clues. What did they think exonerated him? Here's what they said about him, several paragraphs long. I'll read quickly. There are many affidavits and much testimony into the record as to the defendant's character as a fanatical Nazi and ruthless judge. First sentence. There is also much evidence as to the arbitrary, unfair, unjudicial manner in which he conducted his trials. Some of the evidence against him was weakened on cross-examination, but the general picture of him was as a judge of the Nazi regime, which the tribunal accepts. Unfortunately, the records of the special court at Stuttgart were destroyed at the time that the Palace of Justice in Stuttgart was burned. Therefore, there are no records available of the cases tried by Kuhorst. From the evidence available, this tribunal does not consider that it can say, beyond a reasonable doubt, that the defendant was guilty of inflicting the punishments which he imposed on racial grounds, or that it can be said beyond a reasonable doubt that he used the discriminatory provisions of the decree against Poles and Jews to the prejudice of Poles whom he tried. While the defendant Kuhorst followed a misguided fanaticism, certain things can be said in his favor. The tribunal does not consider itself commissioned to try the conscience of a man or to condemn a man merely for the course of conduct for a course of conduct foreign to its own conception of justice. According to training and conception of the law, it is limited to the evidence before it. Upon the evidence before us, it is the judgment that defendant Kuhorst has not been proven guilty beyond a reasonable doubt of the crimes alleged. He therefore must be acquitted on the charges. So you hear high standard of proof, you hear about lost evidence, but you don't hear about gray. There's no mitigation that I heard there. Nothing like the exculpatory focus of the tribunal on Blom's November 1942 letter, where he actually affirmatively opposed extermination of Poles. I think what you do hear there is more like the Sklar imperative for equality. To the extent that there were firsthand accounts of accusing witnesses, they confirm that Kuhorst was harsh to all defendants. He was equally cruel to all. This was significant. I say this with confidence because the tribunal had to make horrible comparisons, such as to Kuhorst's co-defendant, the infamous Judge Rothog, a drunk who conducted show trials interspersed with diatribes against Jews as subhuman. Rothog presided over the infamous Katzenberger case, where Katzenberger was tried, convicted, and executed for violating the law for the protection of German blood, a false accusation that he had defied a German female friend with whom he had no intimate relationship. Rothog had the woman charged with perjury to prevent her from testifying on his behalf. Katzenberger was beheaded. Rothog was promoted to the People's Court in Berlin. Remember, the tribunal here said it lacked evidence of rulings by Kuhorst on racial grounds. So it lacked evidence that his rulings were not just severe and cruel, but were discriminatory, severe, and cruel. I think the significance of negative egalitarianism is also apparent when you listen to Kuhorst's own testimony. In your careers, you're going to learn that when a trial judge interjects to ask a question, those questions, so not the lawyer's questions, the ones directly from a judge, often cut to the bone. In the Kuhorst trial, at one point, the presiding judge of the tribunal dramatically engages in an exchange. He interjects and says, I should like to ask him one question before redirect. He's asking Kuhorst this. Did you, in either of the courts where you were presided, try any cases that were based on the law for the protection of German blood? Kuhorst answers, no, Your Honor. In Stute Court, all such cases were tried by the penal chamber. Question, you didn't try any in connection with the penal chamber? In any court which you presided, did you try such cases? Answer, no, I never tried those cases. President, that's all. Now, trying to do what I did with Blom, where is the Levy insight? Where is the gray zone? What did the tribunal maybe see? Again, it's not in the judgment of acquittal. So this is my inference, but there's a little flicker in the abyss of this man's soul as an affiliate of National Socialism. And when I found it, it jolted me, I think it did the Harvard Law School librarian that I called to ask him if I was really seeing what I was seeing. And he then helped me with access to it because this was an exhibit. So I was reading the transcript they had to specially send the exhibit. If the word pathos connotes anger plus sadness, it's very apt to this. It came as the final defense affidavit supporting Kuhorst. I'm going to read it, and then I'm going to ask you to guess who the affiant was. It's dated July 24, 1947. It was sworn to in the city of Ulm. Only 3 paragraphs long. Paragraph 1. So this is an affidavit submitted on his behalf, defense affidavit. This is the affiant talking. During the trial against my sons, my husband and I had the impression that Mr. Kuhorst knowingly wanted to see the defendants acquitted. The trial of my sons, I had the impression he wanted to see them acquitted, or at least to fall under amnesty. He had a paternal manner of asking questions. Paragraph 2. During the trial in the fall of 1944, when my husband and I, as well as both my daughters, were in police and pretrial detention, those present had to notice that Kuhorst was willing to acquit me and my older daughter, which indeed did happen. From the ranks of the audience in brown uniforms, a cry came, quote, that won't do it all, that these two go free. Today, we are still convinced he knowingly suppressed grave reasons for suspicion against my husband. Otherwise, a much severer penalty, even the death penalty, could have been pronounced against my husband. His attitude had become so obvious. Final paragraph. In both trials, 1938, 1944, neither of my sons were subjected to brutalities or cruelties or horrors. If that were not so, I would not have felt obliged to write a letter of thanks for Judge Kuhorst. Signed by whom? Magdalene Scholl, the mother of Sophie Scholl. So the mother of the girl that had been tried was not allowed to present a defense and then was beheaded before her brother was beheaded afterwards. They were all part of the White Rose movement, the student martyrs. The mother of her wrote a letter. It's not mentioned in the judgment of acquittal. It comes in at the end of his testimony, and I have to believe that it had huge impact, unmentioned by the judges, who knows why. 15 minutes more? Okay, so a conclusion. I think the Nuremberg tribunal, sitting in judgment over such monstrosity, acquitted these two defendants because the tribunals were, of course, facing comparative depravity. In comparison to co-defendants, Blom and Kuhorst seemed like lesser demons. Like others, they let ambition affiliate themselves with an ideology that destroyed two great professions and inflicted unspeakable cruelty and death. There's no doubt both men traded professional neutrality for ambition, conscience for power. Yet each perhaps was saved by one moment of detachment that, for lack of a better term, I would call gray, but which could also be called a moment of disaffiliation, where they disaffiliated with the group that had advanced them so much. Kuhorst, again, who ordered the execution of dozens, did so apparently without racial discrimination, those cruelties, And then the surviving mother of the Scholl family wrote her affidavit that at least once Kuhorst had opposed fealty to Nazi officialdom. Now, that may have led to his demotion, and he was relocated to the Eastern Front. So it was a fairly significant defiance he did on behalf of a family that had been accused of treason and the daughter and son executed. Blom, though he was a virulent anti-Semitic, and though he approved human experiments, he had this one letter that did show resistance, disaffiliation, to the extermination of weaker humans, the 40,000 sick Poles that Himmler and Greiser wanted to exterminate. Thinking about affiliation, bias, and complicity, I really cherish these words from Judge Skelly Wright when he said, quote, after he had desegregated New Orleans, I did it, desegregation, because the Supreme Court had said it. And there wasn't any way out except subterfuge. Other judges were using subterfuge to get around the Supreme Court, delays and so on. But I grew up around federal courts, and I had respect for them. How beautiful in its simplicity. Of course he's right. The only judicial affiliation that the Constitution asks us to make is, and I quote, to administer justice without respect to persons, to do equal right to the poor and rich, and to faithfully and impartially discharge and perform all duties incumbent under the Constitution. That's codified at 28 U.S. Code 453. Now, stepping up a pay grade from where I am, there's Article 2, Section 1, the President's oath of office. It's interestingly both more focused and more expansive. He takes an oath to, quote, preserve, protect, and defend the Constitution. Then there's Article 6, Clause 3, required of all federal and state officials, so all judges, which just has one verb in its command, and that is to support this Constitution. Now, for another lecture on the peril of affiliation, it's interesting to me that the clause doesn't say to interpret, it says to support. And this is also the clause that the framers attached the caveat that, quote, no religious test shall ever be required. Yet close to 70 federal judges across the South, all white males, each with life tenure, twisted, delayed, and defied their oath to support the Constitution, that is, the Constitution as expounded by the United States Supreme Court in Brown. Why? They had a servitude too. To put it more gently, they had an affiliation. It was a societal affiliation, which was dressed up in their minds with a judicial philosophy, professing states' rights. Skelly Wright was clear-eyed. He said that was subterfuge. But it led many other inferior judges to disregard their sworn only constitutional affiliation to support the Constitution. Now, on the subject of friction between the judicial oath and extrajudicial allegiance and sentiment to a group, to a philosophy, to anger at other groups, you may be interested to learn that way back in 1789, our first Congress passed the precursor of 453, which then our first president, George Washington, signed into law before any other law. In other words, the framers perceived at the beginning of our constitutional experiment, the absolute necessity of swearing state and federal officials, especially judges, to one and only one allegiance. Not to country, not to flag, not to a state, not to a party, not to a group, not to a person, and not to a judicial philosophy. Only to support the Constitution of the United States. Now, is it a coincidence that when Hitler took power as the Reich Chancellor and Führer, what he immediately did in the same month as President von Hindenburg died was to revise Germany's oath of office so that state officials no longer swore loyalty to the German Constitution, but instead now swore loyalty to Hitler. Back to you, to law students sort of on the edge of tomorrow and being the lawyers who will defend the Constitution. I wonder sometimes, is there a William Tell in each of you that will help you resist loyalties and put aside heroes that virtually no one can emulate, like Sophie Scholl? Stick instead to familiar leaders who, in moments of choice, resisted affiliation and especially its twin, the disaffiliation of others. George Washington's anathema to factions is well known. His 1796 farewell address cautioned us about that. Less known is a speech he gave a decade earlier on March 15, 1783, to his beloved officer corps in Newburgh, New York. They had convened, the officers, not expecting him to show up, to discuss marching on Congress and insurrection. because Congress hadn't paid them. Washington showed up. Of course he agreed his soldiers deserved to be paid, but he didn't agree to insurrection. Famously, when he stood up to calm them with a congressman's letter that agreed they should be paid, he fumbled putting on his spectacles. You may know this incident. His men had never seen him wearing spectacles, and he apologized, saying, "Gentlemen, you must pardon me. I've grown not only gray in service to my country, but blind as well." And historians tell us the officers fell silent, some cried, and their insurrectionist spirit dissipated. But the grievances festered. Many of the same officers tried something more subtle. They tried to affiliate in a group called the Society of the Cincinnati, with membership only open to officers of the Continental Army and their male descendants. Remember, Washington was sympathetic to these men. The country owed them a great debt. They were his dear soldiers. They deserved pensions. And he even agreed that there was value in fraternal and charitable associations. But overriding favor and friendship, he feared faction above all. And most of all, he feared a hereditary military society right here in America. We know this from his correspondence with Thomas Jefferson. So a second time he shows up and speaks out. This time, historians tell us he told his officers he would support their society, but on one condition, quote, that it strike out every word, every sentence, every clause which has a political tendency. What brilliance. Now, if that's true, that's a great example for those of you here not to affiliate with anyone or any group that politically disaffiliates others. My second and last example won't surprise you, Lincoln. We know he refused to sacrifice equality for advantage, and of course he tried to keep the Union until the shots at Fort Sumter forced schism. I brought with me his Gettysburg Address, all 2 minutes of it, 270 words, a lot fewer words than I've spoken to you tonight. Most of us can recite parts of it in our heads. Do you remember the two verbs that he uses over and over again 8 times? To consecrate and to dedicate. And it wasn't just consecrating and dedicating the Constitution, but it was to the dead at Gettysburg, both the Union and Confederate. And perhaps lore, but on his last day, it is said that he signed 2 orders that show me he shared Schlar's equality imperative as well as Levy's resolve that we see humanity in antagonists. One, he pardoned a Union deserter, writing only that, quote, he'd be of more use above ground than below it. And the second was that he discharged a rebel prisoner who refused a loyalty oath, and Lincoln wrote only, let it be done. So we don't know his reasoning. We've got 2 pages left. So please, law students here, as you enter the profession, don't seek some comfort, never pursue ambition, affiliating with factions and groups that demean others as different, as less patriotic, as less worshipful, because they don't adhere to the correct philosophy. Put as a positive, I'd like to quote Judge Alvin Rubin, who sat on my court before I joined it. I wish I'd been a colleague of his. He said his philosophy, if he had to name one, was eclecticism. Imagine getting through the U.S. Senate today if you say your judicial philosophy is eclecticism. But he said he wanted to inform himself from all available sources. He also devoted himself to the full profession. He wrote over 50 law review articles. He taught while he was a judge, and he was very devoted to the legal academy. If I can give the students here a homework assignment, the Nobel Foundation just announced its prizes. I think you will enjoy if you take a moment to listen to Toni Morrison's acceptance talk in 1993 when she accepted Nobel Prize for Literature. It's been as guiding for me as Schlar's essay, Putting Cruelty First. In it, she critiques how the words we use reveal whether we're cruel or kind. And the constitutional words that often echo in my head aren't actually any words in the Constitution. They're in the transmittal letter of the Constitution to Congress. In the transmittal letter, the framers of our Constitution were candid that they made compromises. And of course, we know they made one terrible one that led to a civil war. But the larger acknowledgement they made is that the Constitution was drafted, although it was drafted in a revolutionary context, it was drafted, in their words, quote, in the spirit of amity. In the spirit of amity. As a judge on a multi-judge court, I see every day how important that spirit of amity is. That reconciling is not compromising. In fact, I think integrating disagreeing viewpoint is much more difficult than writing a solo dissent or a look-at-me concurrence or writing for a lopsided majority and just choosing to ignore dissenting voices. In other words, dissents and separate concurrences are easy and often solipsistic. What's very hard to do is to integrate competing viewpoint, especially viewpoint that you don't have to integrate by virtue of you having a majority opinion. Finally, I'll skip that just for time. Anyway, I want to thank you for listening. Have I saved any time for questions? 20 minutes? Okay. Oh, I didn't mention Frances Kelsey Oldham. Okay, who is she? This will take 2 minutes. And there's a new Oxford Press biography of her, which I've been reading and I recommend to all of you. But she was born at about the same time that Sklar, my mentor, which is largely why I give the lecture, because she has passed away, but I constantly take any opportunity to pass on the lessons that she gave me about avoiding groups, avoiding groupthink, avoiding ideology. That was certainly Justice White's personality. He eschewed any affiliation whatsoever, any special treatment. Sklar was born, Sophie Scholl was born, and this woman, Frances Oldham Kelsey, was born in the same decade. That's when most doors were shut to women, but she joked later about how lucky she was that she'd been given the name Frances, because when she applied for jobs, people thought she was a male, and then they were too embarrassed when they're interviewing in person to not allow her to get the job. Her field was pharmacology, and as I give you a few more hints, some of you will know who this woman is. But with very few job options, she ended up in the federal government at the precursor to the FDA. So that, as you know, is an agency full of public servants and experts dedicated to all of our safety. Thank goodness she did. In the first weeks that she was there as a drug reviewer, she received an application to commercially market a drug called thalidomide. It was the morning sickness pill. There was intense corporate pressure to get her to approve it. It had been approved for use in Germany and in Japan, but with her expertise, she resisted. Huge personal cost, constant corporate pressure. She insisted on more human safety data, and because she did, thousands of children in the United States who were born the very year I was born, 1961, weren't horribly malformed as they were elsewhere in the world. So if that intrigues you, I offer it as an example to trust public servants, to trust experts, become one yourself. I've been in the public service ever since I got out of law school. I was a law clerk, then I became a federal prosecutor, and then on the bench. And I recommend her biography. Well, thank you for listening, and I welcome questions. Should I come sit? Yes.
Okay, so we have about 20 minutes, and I want to leave plenty of time for the audience. But I want to start with a few broad questions based on your talk. It certainly is provocative, right, the claim about affiliation, because much of your jobs, right, and the ability to become a federal judge now has been based in affiliation and groups that can then mediate and get people into the positions like the ones you have. So I guess my question is, having made this provocative claim, what are the correctives?
Well, they may seem unsatisfying to you, but by saying be cautious about the decisions you make to the young professionals who may aspire to be a judge, and therefore, as a colleague of mine, Pat Higginbotham, says, you have to play in the rain if you want to get struck by lightning. So without a doubt, you will be making choices that are professional advantage. I thought a little bit as I came here about Justice Stevens, of course. And in the case that most of you will know, Texas v. Johnson, the flag burning case, he dissented. Now, I think he was wrong. I think Justice Scalia was right. It's a wonderful case to dissect and look at. But why did he dissent? When I read that dissent and wonder about it, I think it was largely out of his affiliation. He had seen military service. Well, that's a very noble affiliation. My daughter's in the Marine Corps. She's a pilot. So when I say be cautious about affiliation, I don't want to be naive. I have the same anxieties as a judge now for 13 years when I look at my colleagues, and presumably they look at me, and there are very good affiliations you still have to be very aware of. Friendships, of course. To a lawyer, you have to recuse. I worry a great deal about judicial friendships with district judges. We're very aware of the district judges whose work product we're reviewing. And judges often, because we are reclusive, and I think should be reclusive, we do have meals with them. We tend to have meals with our co-equals, district judges, different job. And that always gives me a bit of anxiety. As a maybe even more trivial point of anxiety, law clerks. Judges are extremely devoted to their law clerks. Usually after about a year, law clerks will come back in front of you. And it's always interested me in conference how a judge will just sort of feel like a little disclosure is enough. They'll say, oh, you should know so-and-so was my law clerk. And that gives me a little uneasy feeling in my stomach. Now, interestingly, last month was the first time I had a prior law clerk argue 2 in one day. I used to referee my twin daughter's soccer games, and I was definitely harder on them as a referee. But your question is correctives. Well, the best corrective is just be a superb lawyer. If you're a terrific lawyer, you will be able to topple servitudes, biases, whatever word you want to give to it. I mean, the great lawyers did that. Certainly Thurgood Marshall, Ruth Bader Ginsburg, I would say Mary Bonato. They were fighting against prejudgment, predilections. So if you're a great lawyer, aspire to become a judge, be a good judge, be a Skelly Wright, be a Frank Johnson. The 2 judges in the South were able to follow the Supreme Court's unanimous ruling. What else would be corrective? Okay, again, in the spirit of trying to be a little provocative, I would say, unlike some of my colleagues, the more you, and especially law professors, criticize us and are vigilant about us, and when I say us, I mean all judges, state elected judges, federal life tenure judges, we present different problems. So you should scrutinize our opinions. You should criticize any opinion that contains anger in it, any opinion that's a look at me type opinion. I would say criticize what I think of as lazy opinions, which are concurrences and judgment only. This is all debatable. Other judges would appropriately disagree with me. Criticize opinions that cite the internet, which is happening more and more. Certainly criticize when judges in their opinions go outside their lane. And by outside their lane, I mean they are re-deciding facts that a district judge has given them without the deferential standard, or they're ignoring party presentation, or even ignoring precedent. Those are circuit judges that are way outside their lane. I'm not talking about the Supreme Court. At the intermediate level, our only job is error correction. That is our only job. It is not to advance some other growth of the law. And on this little rant, criticize especially extrajudicial activities. Feel free to criticize that I'm here at all. Now, I am choosing to talk about an error from decades and decades ago, but quite a few judges are out there talking to students about current topics, whether it's guns, religion, voting. I always wonder in the back of my head, every federal judge I know, before confirmation, they adhere to what's known as the Ginsburg standard, when she said, no hints, no forecasts. But then they get life tenure and they're going out and speaking on all sorts of topics that could come up before them. Well, you can criticize us. So be a great lawyer, become a great judge, criticize us, and a little more edgy even than that, we have a code of conduct. And you can not only help with judicial selection, but you can put pressure on the judiciary and our code of conduct committee. Go through it, read the advisory opinions. I've twice written to the Chief Justice about 2. Each time I was not successful. One of them was loosening restrictions on judges to recommend other people for political office. Now, it was said to be just stylistic, but it, to me, obscured what had been a bright line rule that judges could never recommend somebody for political office in any 3 branch unless they were called. They received the call from the government entity, the Senate or the White House. If you go read that advisory opinion as rewritten now, it's much looser. Arguably, it allows judges to talk at group events and recommend people. To me, that's a very small but pernicious. I wrote a letter against it. The stylistic edits were adopted. People can interpret it the way they want. Then you probably remember, and it was much more salient in the news, there was an advisory opinion that was proposed, Advisory Opinion 117, which restricted all judges from memberships in groups like the American Constitution Society and the Federalist Society. And I wrote impassioned to the Chief Justice and the Conduct that they should pass that advisory opinion, that I think the appearance of justice is very problematic when judges team up, no matter whether they call it an intellectual organization or deny that it's a political one. The public, I fear, sees an appearance of allegiance. But again, that didn't prevail. Other judges had powerful arguments saying, no, this is intellectual and we don't want judges to be in ivory towers. So there are correctives.
Is that last point, is that about the appearance? Or do you think it does something more substantive?
Well, again, these are provocative points, and you need to ask a lot of federal judges, because I would be criticized, and I deserve the criticism of being sort of nerdy and quite isolationist. We have state judges here, justices, and to the extent I've had the privilege of getting to know state Supreme Court justices, many of them are elected, they have to go in front of the legislature. They have to convene people to resolve all sorts of things. They're running a giant bureaucracy. So my little privileged Ivy Tower conception, now that I've had more exposure to state Supreme Court justices, doesn't really work. I'm mostly talking about the intermediate level appellate judge, whose job is simply to review district court work product and see if there's reversible error. Did I answer your question on that one? Maybe not.
Yeah, I guess I'm just wondering, like, how much is do you think that let's just be concrete about it. Judges should not be a part of the American Constitution Society or the Federalist Society. Right?
And that is certainly not the existing circumstance. And I have gone and spoken. Keep in mind, I am a full adherent and have gone to both groups to speak. It's a delightful privilege. And often the intellectual caliber about important issues is absolutely fascinating. I just worry the American public doesn't understand it. And I am quite convinced that if Justice White were still alive, he would abhor judges being members of these groups. Remember, back to the Senate Judiciary questionnaire, you are asked to list I was told I had to list every library membership I had. And that's important for the American public to know. What are your affiliations?
So I do want to let other people have a chance to ask questions. So if you have questions, please raise your hand. I think we have a microphone. Yes, we have a microphone over there. I am happy to continue my discussion with Judge Higginson, but if there are questions, please raise your hand and we'll bring a microphone. MR?
Yeah. Right here in the front row, second row.
And please do wait for the microphone. This is being live streamed, so the microphone, make sure that we're capturing it.
Very unlike Nuremberg, since 9/11, the U.S. has made no attempt to bring bin Laden, Hussein, or Gaddafi, for example, to trial. Care to speculate as to why?
Why they haven't been brought to trial? I mean, that's asking me to step way out of my lane. Those three individuals, am I even versed politically? Who are the three you mentioned? Bin Laden, dead, buried at sea so that he couldn't be a martyr, correct? So hard to bring him to trial. In a criminal case in front of us, if the defendant dies, the conviction's expunged.
Well, but we
Who's
did
the second
that.
one?
We could have seized him.
Oh, it's a could have.
Well, he was an old, sickly man, and we buried him at sea instead of brought him to trial. And similarly with Gaddafi and Hussein.
Yeah. Oh, we could have, because all three of them. Well, I mean, again, I'm just now mouthing what I've understood that our political officials, they were fearful of creating martyrs, at least in the case of bin Laden. When you do look at Nuremberg, I mean, although I've described it and it's fascinating, that's largely out of my gratitude to Judah Sklar. There's a scene in the movie Breakfast at Tiffany where it said, to those who have given you confidence, you owe them a lot. So this lecture is my thanks to her. She survived that. But the reason I bring that up is her first book, Legalism, was a ruthless criticism of the Nuremberg trials, that it was just victor's justice. Those laws were, the law of crime against humanity wasn't even in place. It's purely an ex post facto law. So there are powerful intellectual critics of these efforts to have political show trials. That might be an answer. It's probably an unsatisfactory one. Judge Tim could have a better answer.
No, those are good answers, and thanks for joining us this afternoon. I'm a Lutheran, and the Lutheran Church back in the Nazi era was the established church of Germany. Did your research show kind of some parallels with church leadership, clergy, and how they similarly reacted to the Nazi regime. There's a great Lutheran theologian, Dietrich Bonhoeffer.
I was going to say Bonhoeffer was
eventually executed by a very well-meaning Nazi judge that went to a lot of trouble to make sure he got a trial before the Americans could liberate Germany. But what was the church's role in that cultural moment?
Again, I just read these two trials at Nuremberg. I would have you not prompted it. Bonhoeffer, to me, is similar to Sophie Scholl, someone who did speak out bravely and paid with his life. The larger question of the role of the church, I think it's quite incriminating. Not the Lutheran Church, but there are historians in the audience, I'm told by Deep. They might be able to answer that better. So I'm not going to give an answer to the role of the church other than to say, I think there was a great deal of complicity. There may have been individual moments of great heroism. Bonhoeffer is the only one that comes to mind. Interestingly, I am aware there's a book written about the 21 religious figures in Mississippi during desegregation that spoke to their congregations about it. All 21 had to flee the state. And that book is not a well-known book, but it's quite, when I read it, I was just stunned at their bravery. I'll take this opportunity to embarrass Judge Timkovich, totally separate subject. Second Amendment is very difficult, right? And our court's getting quite a few remands in light of the latest Supreme Court decision in Rahimi. And so I was trying to prepare for one of them that we heard recently. And I came across, I don't know if you remember it, a 2009 special concurrence by none other than Judge Timkovich. It is a model of the role of a special concurrence, only 3 pages long. So this is pre-Bruin and pre-Rahimi. And Judge Timkovich predicted that Heller was problematic and had to be revisited because its own history wasn't sufficient. But what he also did is what rarely you see judges do, I think. He integrates a great deal of scholarship, which is so wonderful when judges are able to do it. They're not often given it by lawyers. I was telling the students earlier today, when you get to miscellany and table of contents, it's very rare you're given law reviews. So you've got to go find them. And he integrated a great deal of scholarship that was talking about that. And then the other thing that he achieved, more than you can probably tell from my personality, he had no edge in the opinion. I mean, it was close to criticizing the Supreme Court, but there was absolutely no edge. I say that because separate opinions in our court are controversial a little bit, whether circuit-level judges should be writing these separate opinions. Are they writing them for their own audition to maybe get on the Supreme Court, or is it really helping the growth of law? And the Second Amendment is a fertile area for a whole nother lecture. We have time for a few more? One or two?
I think so.
In the middle? Yes, in the middle. Oh, you have to get the microphone.
Thank you for coming.
Oh, thank you for inviting me.
Well, I did not, but,
Maybe you didn't want me here. You should be able to stand up and protest as far as I'm concerned, if anything I said offended you.
So I'm curious what your views of affiliation have on the Constitution's right to association, whether or not you think those fit, whether they don't, whether affiliation is different from association. I'd like to hear your thoughts on that.
Well, my lecture has been trying to situate you in the position that young graduates were back there in the late 20s, which is just saying to you, you should think hard before you affiliate, and especially with groups that denigrate others or that disaffiliate others. So the right to associate, of course, it's a bedrock right. I've written to support it many times. But this maybe gets back to what I'm saying about judicial friendships. I have one lawyer that I'm such a good friend with that I've put him on my recusal list. There's a colleague on my court who, when he got on the court, contemplated having his recusal list comprising every single member of the clubs in New Orleans that excluded blacks and Jews. He was Jewish. And he thought about telling the clerk of the court, I'm recused from any lawyer who has chosen that association. Now, this is a longer subject and I won't go on, but the civil rights area of our court is something I've studied much more than the Nuremberg area. And Judge Wisdom, whose name is on my courthouse, it is the Wisdom Courthouse, is one of the most intriguing of the four. The court was much smaller, and there were four. Jack Bass has written a book called Unlikely Heroes, describing the four. They had a bare majority to uphold Skelly Wright and Frank Johnson, Old Fifth. So it was Reeves, Tuttle, Brown, and Wisdom.
Wisdom's interesting because pursuing the right of association, he was still a member of these exclusionary clubs. Until the day he died, he defended that as vital. He saw himself as a bridge. He was able, therefore, to communicate with groups that otherwise felt utterly demonized by the direction of the law. Now, judge for yourself. The other 2 points I'll mention about those judges whose biographies I've read is most of them had a jolt moment where they were able to perceive their chosen association as a very negative one. For Skelly Wright, he describes it as he was at Christmas time looking out his window at a lighthouse for the blind, and he noticed that blind people that were black were being led into one door and blind whites in another. And he realized the absurdity of it in that moment. Judge Reeves had a terrible case as a lawyer involving a black woman whose daughter, her skin color was quite light, and she got to a skating rink. Because they thought she was white, they gave her skating rinks. But when the mother showed up, they dragged the daughter off the skating course. And at that moment, as a lawyer, he said, I'm committed to ending this, and sort of renounced those associations and affiliations. If that's interesting, the last thing I'll mention, which isn't an answer to your question, I don't mean to sound I can hear myself sounding strident, but in the research, especially this book I recommend, Unlikely Heroes, in the footnotes, there was a very provocative footnote that described an emergency hearing of my court in August of 1963. And that led me down to a lot of rabbit holes trying to find out more about this. What had happened was Judge Cameron, he was the segregationist on our court. He felt it so strongly, and he did describe it as a states' rights view, that he mistakenly admitted to the chief judge he couldn't rule fairly. Well, the chief judge was delighted because that took a negative vote off those cases. But Cameron watched the court's cases, and he observed the panel majorities, and he made a complaint saying, this can't be random. This has to be court packing. There's no way 2 of the 4 would be on 25 of 27 what they called civil rights cases. So he called the clerk of the court and said, I want you to tell me that no one has packed the panels. And the clerk answered, I can't answer that question. This is not really known to history. This is a footnote that I read. And then I dug more because it's sort of against history, right? The good guys. So then Cameron called the chief judge and said, the clerk of the court's got to answer to any judge. What happened there? And Tuttle's response was, we need an emergency meeting. And he called it in Houston in August of 63. As a quirk of history and fate, Cameron got too sick, he couldn't travel. So the one who called the hearing wasn't there. That was very fortunate in terms of what then elapsed. In the hearing, we have Judge Wisdom's handwritten notes and one other judge's notes. It's imperfect, but I think it's fair for me to say to you that Judge Brown was what we call the calendaring proctor. The American public didn't understand that. They just thought the chief judge assigned panels. But in fact, we have a calendaring proctor, works with the clerks. It's got to be random. Brown bursts into tears. He admits that he had told the clerk, this case ought to be heard in September, not August. And the only September panel had a majority. He admitted to a few other horrible abnegations, but Brown is revered, one of the 4. Now, Tuttle, the chief judge, stopped the hearing, as best I can tell, said, let's sleep on it. Then he comes back in the morning, and this shows leadership. He said, since the public thinks that I'm the one who set the panels, I'm going to resign as chief judge. Well, that disarmed all the criticism. He didn't deserve any blame. So it changed, as far as I can tell from looking at the notes, it changed the dynamic. And then interestingly, and I don't think this would happen today, the court, you may even criticize this, Wisdom wrote 3 or 4 sentences, they still exist, it was a court order. Allegations of impropriety, and I'm paraphrasing, have been investigated and corrected. We are confident no case was decided improperly. That was it. And history has never understood that moment. Today, the losers, the Camerons, who we have demonized, and I think somewhat deservedly so, would absolutely have aired that dirty laundry. It's quite remarkable to me that the court understood as a court, its legacy and its institutional role required that to be stated. And I still have very mixed feelings about that moment.
I think we are at time, but there is an opportunity to continue this conversation with Judge Higginson in the reception that we're having right outside in Betcher Hall. Please join me in thanking Judge Higginson.
Oh. Thank you.